Great. Thank you, Chairman.
I would note that Professor Vladeck just said if a majority of this committee thinks that senators subject to subpoena should be notified, that they could pass the law. Well, magically, we used a time machine to do that because Congress passed that into law in 2004. It is in the United States Code. It is black-lettered law, and Judge Boasberg disregarded that. Now, he did so at the invitation of Jack Smith. And I would say my Democrat colleague said, well, gosh, it's standard practice not to tell a judge the number you're subpoenaing. It is not standard practice to subpoena 20% of the Republicans in the Senate and the opposing party. And I'm confident my Democrat colleagues would be really pissed if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded with no basis in fact that the mere fact that they are Democrats demonstrates that they, Senator Hirono can respond, but you can, I'm happy to recognize you to respond, but I would ask you not to interrupt me because I am not interrupting you. I am certain my Democrat colleagues would be unhappy if the Trump DOJ, I'm asking you not to interrupt me, Senator Hirono. I did not interrupt you. I am speaking now, and I will recognize you to respond when I conclude in speaking. I am confident my Democrat colleagues would be deeply unhappy if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded the mere fact that they're Democrats means they are likely to be criminals. And I do want to note also my prediction that no senator would mention Judge Boardman's name proved wrong with the penultimate Democrat speaker. Senator Hirono did mention her name, and 100% of what she said is the decision is on appeal. And I would welcome any of my Democrat colleagues to say that Judge Boardman's decision to deviate downwards by 22 years to reward an assassin, an attempted assassin, the Supreme Court justice is anything but disgraceful, brazen, and encouraging more political assassinations. To defend it as anything other than a complete dereliction and abuse of her oath of office. Senator Hirono, you're welcome to respond.
You know, you talk about using facts. Well, the law that we refer to is not exactly clear on who bears the responsibility for asking who the heck's records are being subpoenaed. And by the way, if you want to blame somebody for the fact that 20% of Republican senators' records were subpoenaed, you can blame President Trump because he's the one who was calling all of you, or he had his minions calling all of you. So there you go. That's all I have to say.
You know, it is an amazing statement that Democrats now believe that the fact that a member of the Senate speaks to the President of the United States is sufficient to subpoena their phone records and presume they are criminals.
Why don't we move on?
Senator, you don't get to say move on because you don't have the gavel, but I will say this. Sad to say, well, perhaps if you hadn't presided over a disastrous economy and an open border and wars across the globe, you might still have the majority, but you don't. And my point is very simple. It is not a criminal conduct to speak with the President of the United States, and it is ludicrous to suggest that it is.
And of course, I didn't make that suggestion, so that's why I'm saying, can we move on with this?
And while we're doing that, since Professor Vladeck mentioned a letter from Director Conrad at the Administrative Office of the United States Courts, I'd offer that letter that he mentioned as an additional exhibit.
The letter will be admitted without objection.
During the heated Senate exchange, one lawmaker pushed back sharply against claims made by a legal expert, arguing that the issue before the committee was already settled law. The senator noted that Professor Vladeck suggested Congress could pass legislation requiring senators to be notified when they are subject to subpoenas. However, the senator emphasized that Congress already did exactly that in 2004. That requirement, he said, is written clearly into U.S. law, yet was ignored by Judge Boasberg at the request of Special Counsel Jack Smith. Responding to a Democratic colleague's defense of the subpoenas as standard practice, the senator rejected that claim outright. He argued that it is not standard practice to subpoena 20% of the opposing party in the U.S. Senate. He added that Democrats would be outraged if a Trump-era Justice Department had subpoenaed 20% of Democratic senators and suggested they were criminals simply because of their party affiliation. The senator also addressed comments referencing Judge Boardman, criticizing her sentencing decision that reduced a sentence by 22 years for an attempted assassin of a Supreme Court justice. He called the ruling disgraceful, an abuse of judicial authority, and warned it could encourage future political violence. He then yielded the floor to Senator Hirono, who responded by saying the law surrounding subpoena responsibility is not entirely clear. She added that if blame is to be assigned for the subpoenas, responsibility lies with former President Trump, alleging that he or his associates contacted Republican senators directly. The exchange escalated further when the original speaker responded that it is alarming to suggest that speaking with the President of the United States is grounds for criminal suspicion. He emphasized that communicating with the President is not criminal conduct and called the idea ludicrous. As tensions eased, Senator Hirono requested to move on, and the committee proceeded with business. A letter from Director Conrad of the Administrative Office of the U.S. Courts was introduced into the record and admitted without objection.